Hello, my name is Alexander Hinkie, and I will be discussing the Oncale and Sundower Services Inc. Case of 1988. This case took place when Joseph Oncale was working for Sundower on one of their oil platforms in the Gulf of Mexico. There, he claimed to be threatened and humiliated, as well as physically assaulted by several men he was working with. This eventually forced him to leave his job, and he sued them under the Title VII Act of the Civil Rights Act of 1964, which made it illegal for employers to discriminate against employees based on their sex. The lower courts dismissed this case, saying that it's not between men that discrimination, especially sexual discrimination, takes place, but it's only between men and women. And the Title VII, a little bit of a disagreement occurred on the Title VII Civil Rights Act and the way that it was worded, that it was eventually appealed and then brought forth to the Supreme Court. Now, the Chief Justice of the Supreme Court at the time was William Rehnquist, as well as the other justices, Antonin Scalia, Ruth Bader Ginsburg, Sandra Day O'Connor, Anthony Kennedy, Stephen Breyer, Clarence Thomas, David Souter, and John Paul Stevens. These were all the justices at the time, and as I said, William was the Chief Justice at the time. And they had one really simple question to answer. Does the law that bans sexual discrimination for men against women or women against men also happen for men against men in this case, or women against women in other cases? And eventually the justices did come to a decision. It was unanimous, and they all voted for Oncale, saying that just because it's harassment, sexual harassment, does not mean that it has to be only between men and women. Sexual harassment can happen between men and men, or women and women, as in this case it happened between men and men, and there's no denying that. And since it was unanimous, there was no dissenting opinions, but they did make some clarifications, saying that not all jokes or even rough manner in the workplace is sexual harassment, or even just harassment at all. They just have to make sure to not create a hostile or abusive work environment, and that can include with jokes. You can joke, but just not threatening anybody or harassing anybody while doing so. They made that very clear just to make sure. This case did make a big impact on business law as well. Companies were now responsible for preventing and addressing sexual harassment in the workplace. Now, this was different from earlier because they weren't always told to do that. It was kind of understood that you shouldn't do that in the workplace, but now the companies were forced to actually implement policies, as well as make sure that all employees knew the procedure to tell the company about sexual harassment that was happening around, just in case. And it could happen between men and women again, so they also had to look out for that as well, not just between men and women anymore, but between same-sex harassment as well. In conclusion, this case helped clarify the workplace discrimination laws and how they applied more broadly than was originally thought. As I said, it was originally thought that it was just between men and women, but now we know it's between men, women, men and men, or women and women. It can happen between anybody, any level of position. Anybody can harass anybody in the workplace, and it needs to be addressed swiftly to make sure it does not continue. It also expanded the protection for employees, making, again, businesses forced to make it more of a safe and a respectable environment, instead of just letting anybody say anything at any time, not considering how the other person would feel either threatened or harassed. It really put in perspective how this could turn into something big, as it did with the case in 1988. Thank you so much. Thank you.